Hey Zach, how are you?
Hey Ron, how you doing?
Good. I understand you have some questions for me?
I do. So I wanted to start off by asking, what exactly is a foreclosure?
Well, a foreclosure occurs with a mortgage. I'm going to operate under the assumption that we're talking about residential.
Yes.
And it could be an individual or a couple. Basically, you missed a series of payments, typically 4 or more payments. Very rarely do I see a foreclosure start missing 1 payment or 2 payments or 3 payments. A foreclosure after 4 months of non-payment, the lender's tired of making phone calls. They want to show you that they mean business. So what they do is they have either their legal division or an outsourced attorney file paperwork, and it's a summons and a complaint, and it's sent to you as a foreclosure notice, and it's done through the state courts, typically through the Supreme Court, and you get the notice. They strive to serve you personally, and it basically says that we are going to have to act on our right to foreclose on your home because you're delinquent on payments.
Well, I received a notice of pre-foreclosure. Now, what can I do to stop that?
Pre-foreclosure notices, I've noticed an increased trend recently, this being 2010. These types of notices are coming out where the lender is giving a notice in a manner that I haven't seen before, where they're saying it's a pre-foreclosure notice where we're telling you that foreclosure is right around the corner, and they typically send that out after about 3 months, 90 days. And it's your rude awakening that you got to do something now, because they're telling you next month, or very soon thereafter, we're coming after you. Now, through many clients I've worked with, interestingly enough, when I see these come in, the truth is that even if you don't work something out with them the first month, you get another notice the next month, and you get another notice the next month. So sometimes these pre-foreclosure notices actually doesn't necessarily mean trouble's right around the corner. But on the written face of what the words say, it does look threatening.
Right.
And I can show you some examples of what they look like. Bottom line is that when you get one of these, you don't blow it off. You treat it seriously. You should be contacting an attorney and finding out what you can do to deal with it, whether the bankruptcy is in the cards or not, with dealing with that foreclosure. Incidentally, we're here in Suffolk County, and in Suffolk County, in all of the state of New York, the largest number of pre-foreclosure notices has gone out in all the counties in the state of New York. Recently, in the first quarter of 2010, I read an article that came out in the local newspaper that showed all the statistics.
Now, what if I don't want to file for bankruptcy? I heard something about a short sale. Can you explain what that is?
Yeah, a lot of times someone may not be in a financial situation where a bankruptcy would make sense for them. For example, they may not have a lot of credit card debt or other types of debt that they would seek to write off. They just have an issue where they're behind on a couple mortgage payments, but they've also decided that for whatever reason they don't want to stay in the house, whether it be marital issues or they were living with some friends and it didn't work out, or for whatever reason they want to get out of the house, but they don't want to file a bankruptcy to get out of the house and solve that problem. Or they want to just find a way to give the property back to the bank and walk away without a bankruptcy. At the end of the day, you can cut a deal with the bank and say to the bank that you found someone that wants to purchase your home, but the person wants to purchase the home for a lower value than what you would expect them to pay on any given market. And the reason why it's called a short sale is the bank is actually going to be getting a number that's lower than what the normal sale price would be, to the point that it pretty much covers the mortgage or some number lower than the mortgage. So the bank is shorted under the circumstances. So I'll give you an easy example. Let's suppose that a house is worth, you think it's worth $300,000 and the mortgage is worth $300,000, and at the current market right now it's a buyer's market. So for you to put this out and list it with the realtor is going to get a 4% commission for the most part out in this area. By the time you get done with the transaction, you're actually going to be in the hole on selling the home. So what you do is the typical short sale transaction is someone lists their home with the realtor. They explain to the realtor, we want to try to do a short sale with the lender. The realtor tries to find someone that's willing to buy the home. They tell the person, make me an offer, and the offer is a lot less than the $300,000. The offer might be, say, $220 or $230. You take that offer, you go back to the lender, and you say to the lender, listen, can we do a short sale on this? In other words, where you take it on the chin and not get paid the full amount that
Mhm.
you're supposed to get paid for this, but otherwise you risk us not paying and going into a default, or you guys having to foreclose. And oftentimes the lender will take it if the person that's coming and looking to buy it at the discount meets certain criteria. Can't be a family member, for example. You can't have concocted this so that you get a better deal and then sell it back to yourself afterwards. You can't do any hokey pokey types of things like that. And the deal has to be in good faith. The person, of course, has to qualify to be able to go through with the financing to take the lender off the hook. But that's basically how a short sale would happen, and it is a solution. There are a lot of short sales that are going down. In fact, what's interesting is that if you look at the given market and you take a look at all the houses for sale, you can go to various websites like the MLS websites. You might see there's 200 to 300 houses for sale in your market. What the heck's going to make your house sell faster than the other houses? Well, a repressed price. How are you going to get a repressed price? Well, if the bank's willing to take the hit. So if the bank's willing to take the hit, now you're out of the 3 houses out of 300 that a couple that's buying might make an offer on. You've just increased your odds, and with the short sale, you've put yourself, because they're getting the deal. They're very interested in pursuing getting the best deal because they got all these other choices.
Now, what about a loan modification when regarding foreclosure? Is that also an alternative?
Well, sometimes folks come in and they're saying they want to get rid of the house, they can't afford it, and I say, well, what have you done to explore a loan modification, which means modifying the terms on the loan. Now, it's not to be confused with refinance. Refinance is something that lenders recently have been resisting doing, which is basically redoing your loan paperwork so that you're refinancing. With a loan modification, what you're doing is you're taking your loan scenario and you're either spreading out the years, or you're changing the interest rate, or some combination thereof. At the end of the day, they're looking to try to find a way to lower your monthly payment, because you're saying, I need help. If I Mr. Lender, I can't make the payments with the current number that you're throwing at me every month. So if you could work it out somehow so that I'm paying a lower monthly payment, I can afford to make the monthly payments, and therefore I could stay in this house and not have to have it foreclosed upon. So that's where the loan modification would come into play.
Right. Now, I also heard about something called a deed in lieu of foreclosure. Does that happen often in New York?
A lot of people have asked about that, and a lot of people in other states it's a viable alternative. But a deed in lieu of foreclosure is basically saying to the lender who, let's say the lender has started a foreclosure process, some owners want to say to the lender, listen, I'll sign the deed over to you. You don't even have to go through a foreclosure process, and I'll get out, and then you just don't chase me for any deficiency, and you go and auction and do whatever you do with that property. In all the transactions that I've done, we've done many of these transactions, no lender here in New York has been willing to do a deed in lieu of foreclosure. I do have some theories as to why they haven't done them in our area, but suffice it to say that that's probably not going to happen in a New York-based transaction, at least in the current market conditions.
All right. Now, what is the typical foreclosure process?
Well, once someone gets served a notice, let's suppose that 4 months have come and gone, you haven't made a payment on a house. The payments that were missed, the bank views that as an arrearage, so that you still owe it. And they serve a foreclosure notice. They either use in-house counsel or they use an external attorney. They send you a summons and a complaint. It's a lawsuit. You're sued. And it's basically saying that, pay up, or we're going to reserve our right to foreclose. If you pay up and you can come up with some kind of lump sum, they'll do what's called a reinstatement, and then barring any other complications, you're back on track with them, and then you continue to make monthly payments. Of course, nobody ever is in a position to do that, so you end up having to look at other alternatives. Now, once that notice comes, you're obligated to file an answer, depending on how you're served, within 20 days to 30 days. And if you don't file an answer, they can move forward with moving the action forward without your participation, which is not recommended, because it's basically coming to the lawsuit. They come to lawsuit, you don't come to lawsuit. They tell the judge what they want. The judge they get their way from the judge. Responding to it with an answer, there's various defenses. It could be that you've made payments and you've made arrangements with them and they haven't applied payments, or you're not happy with the terms. It was an adjustable rate mortgage and they got their numbers wrong. They misrepresented something to you. There's all kinds of defenses that you could build into that. And there's also by building in an answer and communicating with them. At the end of the day, if you're just behind and you don't really have any true defenses, you should still go through the motions of the litigation to begin a communications process with them to try to work out either loan modification or some kind of other arrangement. So when in terms of timing, once you get that notice and you file an answer, the lender has the opportunity to continue with the legal process and eventually bring it into a hearing, which is a foreclosure hearing. Here in New York, they have these things that are called conferences, where you and whoever else has borrowed the loan goes to this conference, and the lender typically doesn't send someone to these conferences, and you're sitting there with a person that helps represent to make sure that you have the financial information that you would need to be able to present later on when you go to a hearing in front of a judge. And then several months later, which could be 9 months later. Right now, I went to a seminar where I was listening to one of the judges that's down in Riverhead discussing their backlog, and in some instances their backlog 9+ months in terms of actually getting these conferences. So anyway, it could be several months down the road before you actually get into one of these conferences, and then you present your case, the lender presents their case, and if all that time you haven't worked things out and you continue to get more and more into an arrearage, and if you haven't done any kind of foreclosure in the interim, any kind of bankruptcy or any kind of loan modification or anything in the interim, down the road you can't continue to say, I'm not going to make payments and keep the house. There's going to be a point in time down the road through the legal process where the judge is going to rule, well, listen, you can't keep the house without making payments, you're going to have to surrender it. So that process could take as long as 18 months here in New York. I've seen cases where people said, listen, I can't make the payment, I'm not going to do it, and the foreclosure process starts. In the bankruptcy, they even said, I won't argue with the lift-stay motion. The lender makes a motion to lift the stay and continue with the foreclosure process. I surrender, take the property back. The nice thing is in the bankruptcy, they can't chase the individual for the deficiency. In other words, if the lender is allowed to take the property and foreclose the thing, and then if there's a shortage, they can't come after the person in a bankruptcy for that deficiency. But anyway, once the lender comes through and they pierce through, people can live there for several months until the whole thing takes its course. And then eventually, if someone squats in a house and they get the right through the court, if the bank gets the right through the court to evict the person, they can actually take it that far. It actually evict the person from getting into a house. So from beginning to end, it could take 18 months or longer in some instances for a foreclosure to run its course. Now, the majority of people that we're working with want to save the house, so we're looking at one of these other types of things. Typically loan modifications to try to work something out with the lender, or in the case of a Chapter 13, we might do a Chapter 13 instead of a 7 to work out dealing with the arrearage. Or in some cases, in a 7, we'll do a Chapter 7, get rid of all the credit card debt, and we'll do some kind of modification with the lender to make it work.
All right. Well, thanks a lot for your advice, Ron.
You're welcome.